straight ahead on Law and Crime Daily.
You see how, I was holding him, see how his arm, we had a close relationship. He was me and my wife's first child.
Emotional testimony as Daunte Wright's father takes the stand in Minnesota versus Kim Potter. Plus, a return to New York as the defense begins its case in Ghislaine Maxwell's sex trafficking trial. And closing arguments begin in the trial for former Theranos CEO and founder Elizabeth Holmes, when the case could be handed to the jury. Plus, convicted sex offender Harvey Weinstein back in the spotlight. Could one of his convictions be thrown out? Law and Crime Daily covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Brian Buckmeyer along with Terry Austin. We're starting off in Minnesota where the state rests its case in the trial of ex-cop Kim Potter. Potter is accused of shooting and killing Daunte Wright during a traffic stop earlier this year. The prosecution began its case with emotional testimony from Wright's girlfriend and his mother. The state closed its case with another emotional witness, Wright's father, Aubrey Wright. Wright told jurors about his close relationship with his son and the tight-knit family get-togethers, movie nights, and cookouts they hosted. He served as a spark-of-life witness testifying about his experience seeing his son become a father.
Man, to see him as a father, it was like I was so happy for him because he was so happy. He was so happy about Junior. This was my chance to be a grandfather.
Did they have a close relationship?
Yes.
And did Daunte Jr. spend a lot of time with your family as well?
Yeah, Daunte Jr., Daunte lived with us. Junior was pretty much there every day. And he loved his son.
And do you love your son, Daunte, a lot as well?
A lot. I love Daunte. He was loved.
Do you miss him?
I miss him a lot, every day.
Potter faces first and second degree manslaughter charges stemming from the shooting death of Daunte Wright in Brooklyn Center, Minnesota in April. Officers say Wright was pulled over for an expired tag. Wright told his mother he was being pulled over for an air freshener hanging from his rearview mirror. Body cam footage shows officers attempting to arrest Wright after they determined he had a warrant out for his arrest. Amid a struggle, Wright gets back into his car as Potter shoots him in the chest. He died as a result of those injuries, as his car sped away and hit another car. Potter maintains she accidentally pulled her handgun instead of her taser. There's been debate over whether her use of force was justified. On Thursday, the defense called its first witness, another expert on use of force, Stephen Imes. Attorneys asked him about Potter's use of her firearm and whether her fellow officer could have been injured in the traffic stop, as they argue he was halfway in Wright's car on the passenger side just before the car sped off.
The question, sir, would be answered first by just understanding the basic decision-making process involving deadly force, and that is, can I reasonably articulate a belief that myself or another is in immediate danger of risk of death or great bodily harm. So if that's the standard, as an officer assessing the appropriateness of deadly force, an officer half in and half out of a vehicle that is about to be put into drive with the door open would certainly meet that standard of being in immediate danger of death or serious physical injury.
Okay. So an officer seeing that could shoot?
It would meet that standard, and an officer could shoot, yes, sir.
Through the Kim Potter trial, the shadow of Derek Chauvin's case has always been close by. Wright was shot and killed just outside of Minneapolis as Chauvin was on trial for the death of George Floyd. A connecting link between the cases is Courtney Ross, the fiancée of George Floyd and the one-time teacher of Daunte Wright. Law and Crime Network spoke with Ross and several peaceful protesters outside the Hennepin County Courthouse this week.
I don't think anyone wants to be in the limelight for losing someone. It's a horrible feeling. I will say though that I was saying earlier, like it's my lifestyle now. This is my role through God now. So it's my job now to fight for other families that don't get the attention that Floyd got. And there's so many. I mean, I even fret today. Like I fret every day with Daunte's case I pray that it gets more light. I pray that more people are interested, because the more attention, the more pressure. And then we will see a guilty verdict.
Joining us today is criminal defense attorney Julie Rendelman and Terry Austin. Julie, the defense's use of force expert seems strong on direct, but on cross, we learned he didn't view or recall all of the evidence. How's that going to play out?
So look, anytime you have a witness testifying for either side, you have to wait for the cross-examination, because you have to kind of, as a jury, look at the direct and the cross to see how they do on both ends. I will say, I think either way, he did a very good job. Look, I was a Brooklyn homicide prosecutor. We saw cases where individual officers who did stops were pulled. I know a specific one where they were pulled and almost killed and were permanently brain damaged. So that there's something there that the defense has to work with. And the issue is whether or not the jurors are going to buy those two things they're selling, in terms of A, the reasonableness of what she did, and B, whether or not she would have had the right to use an actual loaded gun at that time. Obviously, it's up to the jury, but I think this witness did a pretty good job, even with the issues regarding the prosecution cross-examination.
Now, Terry, there were many officers, some that worked with and above Kim Potter. How did they testify during the defense's case?
The defense is trying to show two things with these officers. First of all, that Kim Potter was law-abiding and peaceful, and also that she used reasonable force. Like Julie said, the expert testified that what she used as far as that taser was concerned was reasonable. But as far as the peaceful and abiding, I thought the officers who got on the stand were a little weak. They were limited because the judge limited them to those issues. But, you know, it's up to the jury to decide whether or not that really makes a difference to them.
All right, we'll see how this case continues as more testimony rolls in, the case of Minnesota versus Kim Potter. Still ahead on Law and Crime Daily, the final chapter in the months-long fraud trial for former CEO Elizabeth Holmes, as the jury hears closing arguments. But first, defense attorneys for British socialite Ghislaine Maxwell called their first witness in the federal sex trafficking trial in New York. All that and more still ahead.
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTubeTV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTubeTV today and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTubeTV. We put you in the jury box.
Welcome back to Law and Crime Daily. The defense begins its case in New York as Ghislaine Maxwell's federal sex trafficking trial started back up on Thursday. The 59-year-old British socialite is charged with 6 felonies, including conspiracy to entice minors to engage in illegal sex acts and transportation of a minor to engage in an illegal sex act. The charges stem from her relationship with former financier Jeffrey Epstein. Epstein was charged with similar crimes in 2019 before he was found dead by suicide in his jail cell. Federal prosecutors say Maxwell and Epstein groomed girls as young as 14 years old for sexual abuse. The prosecution rested its case Friday after 10 days and 24 witnesses testified. 4 of them were women who say they were sexually abused by Epstein when they were underage, and that Maxwell enabled it to happen and sometimes participated herself. Maxwell's defense is arguing she's a scapegoat for Epstein's actions. Law and Crime Network's Adam Classfield has been following this case from the beginning and was inside the courtroom as the defense called its first witness. He joins us now with the latest out of New York.
We are here in front of the Thurgood Marshall Courthouse for the opening day of Ghislaine Maxwell's defense case. They started off with a witness that we long anticipated would take the stand, Elizabeth Loftus, who is a defense expert who testifies on the science of what she calls false memories. Now remember, Ghislaine Maxwell's defense team is going to try to answer the testimony of 3 compelling government witnesses and a 4th witness who essentially accused Ghislaine Maxwell of facilitating Jeffrey Epstein's sexual abuse and in some cases participating in the abuse from the ages of 14 to 17 years old. She is something of a celebrity witness. She has either consulted with or testified in the cases of Bill Cosby, Harvey Weinstein, O.J. Simpson, and many others. As a matter of fact, on the witness stand today, she said that she testified in more than 300 cases. Only 5 or 6 of those were consulting with the prosecution, and only once has she testified for the prosecution. This is Adam Klasfeld reporting for the Law and Crime Network.
Thanks, Adam. Let's bring back criminal defense attorney Julie Rendelman and Terry Austin to break down the newest twists in the Maxwell trial. Terry, what is the argument being developed by the defense witness, and is it spelling not guilty?
I don't think so. There are only a couple of things they're trying to say. They're saying that she's a scapegoat, as we've discussed, and that because you can't get to Epstein, they're trying to get to her. And they are also trying to force the jury to think that these, accusers are lying. And, those two things could very well backfire on them. There were some inconsistencies with Jane. The prosecution was trying to say she initially told FBI she didn't know the first time Maxwell and Epstein were together. And she admitted now she knew when that occurred. And it could very well look like to the jury that the prosecution is blaming the victim here. So I think saying things like, "Are you crying on command?" to Jane is not going to help either. So I don't think their arguments so far are working. But at the end of the day, I think the jury might just try to use Maxwell.
Now, Julie, the defense did something very interesting. It's unique and at least as far as I know, unprecedented, to ask that the witnesses for the defense remain anonymous, similar to that of the prosecution. Now, that was denied by the judge, but your thoughts on the request and the denial?
Well, it's funny you said unprecedented because the judge agreed with you because it was unprecedented, and that's why the judge ruled against them. Look, it's one thing for the prosecution to ask for alleged victims of sex crimes to have their names not out there to protect them. There is case law that supports that. There is no case law that supports the idea that every witness, no matter who they are, can come in anonymously simply because they don't want their names out there. They didn't raise any actual valid issues in terms of safety or anything like as you would with potentially an undercover officer, for example. And because they didn't, they really had no basis to do it. The judge denied it, and it wasn't a shock.
Yeah, interesting argument, but didn't really seem to have a leg to stand on. And it happens from time to time, a judge does agree with me. So thank you for that, Julie. Moving down to Texas, where the trial for ex-police officer Aaron Dean is being delayed. His defense team says 2 witnesses had scheduling conflicts with the result of the trial, which was set to start in January. The former Fort Worth cop is accused in the 2019 shooting death of a black woman. In October 2019, Dean responded to a welfare call at Tatiana Jefferson's mother's house. Jefferson heard Dean and another officer walking through her backyard when she grabbed a gun from her purse. Dean fired the shot through a window, which hit Jefferson. She died as a result of her injuries. At the time of the shooting, Jefferson was babysitting her nephew. If convicted, Dean could face a sentence of life in prison. Aaron Dean's attorneys are also pushing for the trial to be moved out of Tarrant County, saying the extensive news coverage will make it impossible to have a fair trial. Jury selection will now begin May 9th, with the trial to start a week later. Another trial delayed in Los Angeles, where the trial of a man accused of gunning down a well-known rapper in 2019 is postponed yet again. It's been more than 2.5 years since Eric Holder allegedly shot and killed the rapper known as Nipsey Hussle outside his LA clothing store. Holder's trial has faced several delays so far, starting with the COVID-19 pandemic. Holder's former attorney also resigned after receiving harassing messages and threats. On top of that, a previous judge retired before Holder's case could go to trial. The latest delay comes from the state, as the prosecutor in the case had surgery and is still recovering. The trial is set for this coming January, but on Wednesday it was postponed to begin in March. The trial could possibly now overlap with the 3-year anniversary of the shooting. Coming up on Law and Crime Daily, closing arguments begin after months of testimony in the fraud trial of Theranos founder Elizabeth Holmes. Plus, could a convicted sex offender's rape conviction be thrown out? Details on the appeal from former film mogul Harvey Weinstein. Welcome back to Law and Crime Daily. Closing arguments begin in the federal trial of Elizabeth Holmes. The prosecution began with its closing arguments Thursday morning, saying Elizabeth Holmes had the chance to be honest, but she chose instead to defraud investors. Prosecutors said, quote, that choice was not only callous, it was criminal. Prosecutors argue that Holmes' text messages and emails show that she had knowledge about Theranos' shortcomings and had intent to commit fraud. The defense is expected to follow with closing arguments. Then the prosecution will have a second closing before the case is handed over to the jury, which could possibly happen as soon as Friday. Holmes is the founder and former CEO of Theranos, a Silicon Valley lab touted as being a breakthrough blood testing company. She's accused of lying about the technology to investors to get more funding. She once claimed the now defunct company Theranos would revolutionize blood testing, but later tests found many issues with the technology. Holmes is charged with 2 counts of conspiracy to commit wire fraud and 9 counts of wire fraud. If convicted, she could face 20 years in prison plus restitution. Back to break down closing arguments is criminal defense attorney Julie Rendelman and co-host Terry Austin. Terry, what major takeaways do you think the jury took from the prosecution's closing?
I think they're probably trying to determine whether or not this was just exaggeration and puffery or whether or not this really was fraud. The prosecution is clearly trying to make it seem more than just overpromising and underdelivering. They're trying to make it seem as though she intentionally misled investors and clients and partners. They're explaining, and they will talk more about this, that she intentionally misled investors and she, knew the machines weren't working and she used machines from other companies. I think the jury's going to think about all that and wonder whether or not she did this intentionally or she was just trying to promote her company like lots of people do in Silicon Valley.
All right, now, Julie, on the other side, how is the defense going to respond and raise any kind of reasonable doubt to try to win this case?
Look, their defense, basically, even though they called several witnesses, really relied on her. She testified, what was it, 7 or 8 days under cross-examination. And at the end of the day, she gave a complicated, a bit confusing, a bit inconsistent level of testimony that in many ways blamed her boyfriend at the time for his for domestic violence towards her that caused all these things to happen. I think that's going to be a problem. I think the jury's not buying that. And I think the best thing they have is what Terry kind of talked about, is the idea is, did she intentionally defraud investors or did she use puffery? I mean, that is kind of the thing that the jury's going to have to decide. And I think if they push towards the domestic violence, the jury's not going to buy any of it.
All right, we'll see how it plays out. Again, we've just got more closing arguments, both for the defense and prosecution, and we'll give you updates as we continue. When we come back, a disgraced Hollywood filmmaker's lawyers work to get a sexual assault conviction overturned. The arguments Harvey Weinstein's attorney is making to appeal. Welcome back to Law&Crime Daily. Disgraced movie producer Harvey Weinstein could have his conviction on sex crimes charges in New York thrown out. At a hearing this week, appeals court judges questioned what they called prejudicial evidence used to convict Weinstein. The judge in the New York case allowed 3 women to testify for the prosecution about their claims that Weinstein assaulted them. However, Weinstein was not charged with assaulting those women. Law&Crime spoke with Weinstein's attorney in the New York case about the conviction last summer.
These are all women of adult age, all women who, at least in my case in New York, and some of the LA witnesses who testified as other crimes witnesses in New York, all testified to the fact that they wanted something from Harvey Weinstein. And so, the question becomes, can we put all these cases in the same box? And I really don't think that we can. I will maintain until the end of my career, or maybe until my grave, that they did not have enough evidence to find Harvey guilty in that case. And they did find him not guilty of 3 of the counts. So, that's something to think about.
Weinstein is in jail in Los Angeles awaiting trial. A judge refused to dismiss his case last week. And one of the first of Harvey Weinstein's accusers, actress Rose McGowan, won't have her lawsuit case against him heard in court, which is separate from the sexual assault allegations. This comes after it was dismissed by a California judge last week. The lawsuit accused Weinstein and his attorneys of trying to silence her from coming forward with rape allegations. The judge says McGowan missed the deadline to file paperwork in her case. Her claims were dismissed with prejudice, meaning she can't refile the same claim again in that court. Julie, the main issue in this appeals case seems to be prejudicial evidence. What exactly is that, and where is the line for prosecutions when presenting that in a case?
Look, we saw this in Bill Cosby, although they overturned for different reasons. I mean, the issue is whether or not the judge allowed extrinsic evidence into this case to such a degree that the prejudicial value of that evidence outweighed the probative, meaning did the jury basically find him guilty because he's just a really bad guy based on this extrinsic evidence, or because he actually committed the crimes of which he's charged? And that's an answer obviously I can't, speak to. And so that's a question, obviously, that the appellate division is deciding. And so I think that it looks like there's a problem for the prosecution, because the prosecution doesn't have an answer to the questions when they say, don't you agree this is overkill? And so that's the problem at this point.
Yeah. Now, Terry, I know it's reading tea leaves, but that's what we do here. Based on the justice's response, where do you think this appeal is heading?
Well, you know what I think is very interesting? It's an all-female bench on this Court of Appeals, and it's hard to say what they're going to ultimately decide, but based on their comments, it does seem as though they are leaning to overturning the decision, and that the argument the prosecution was trying to make, and one of the judges said it rubbed her the wrong way. So I think there is a distinct possibility that we could see something like that. They certainly didn't agree that character should have come in. Julie's right. They thought that that was too much and that it was not probative and it was more prejudicial than anything else. But I do think that if, in fact, it's overturned, we're going to have a lot of outcry, because this is, again, going to be the second time that this is happening. And it's definitely going to be a setback as far as the Me Too movement is concerned, when you have two big individuals like Bill Cosby and Harvey Weinstein, and their judgments are, overturned. So we'll see what happens.
Yeah, definitely affects prosecutions going forward as well. Well, thank you both, and thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.